When it comes to protecting children from strangers, child molesters, rapists, and pedophiles, we do want children to be safe from predators and do everything in the world to protect them. However, sometimes, children, parents, and the legal justice system cross the boundary line and go way beyond it to the point that they get an innocent person in trouble with the law or assaulted by a child's father or mother or other relative when they just want to sometimes have fun and play at an older age or maybe have interest in helping children that you may not even know about. Children tend to lie and make up stories, and so do their parents sometimes. Here is a list of 10 times an innocent person got hurt because of a false child sex abuse allegation. Number 10. A man who spent the 16 years in prison for the sexual assault of 3 women in LA County was exonerated on Monday, November 23, 2015 after recently tested DNA evidence pointed to the long-sought teardrop rapist as the likely attacker. Luis Lorenzo Vargas breaks down in court on November 23, 2015, as he is exonerated for 3 sexual assaults that he was convicted of and spent 16 years in jail for. Luis Vargas, 46, was sentenced to 55 years in prison in 1999 for raping a 15-year-old girl, and attacking and attempting to rape 2 other victims, the Los Angeles Times reported. Upon his conviction, Vargas told the court, "I'm concerned, the individual who really did these crimes might really be raping someone out there, might really be killing someone out there," according to a news release from the California Innocence Project at California Western School of Law. Vargas' case first grabbed the attention of the Innocence Project in 2011 because it was riddled with textbook post-conviction red flags. The most prominent red flag of all, eyewitness misidentification, the organization's website stated. The prosecution's case relied heavily on eyewitness identification, which included victims noting their attacker had a teardrop tattoo similar to the one victims of the teardrop rapist have described, according to members of the Innocence Project. Vargas, who previously served time for forcibly raping a girlfriend, according to the Times, later wrote to members of the Innocence Project about his case. He said the teardrop rapist and he had a similar tattoo and description: a middle-aged Hispanic man with a small build. In 2012, members of the project requested DNA testing be done on evidence collected from the crime scenes that had not previously been examined. The testing showed the DNA did not match Vargas but was very, very close to the DNA collected from victims of the teardrop rapist, Michael Seaman-Cheek, with the Innocence Project, told the Times. The project also noted the 3 assaults Vargas was convicted of occurred within a 1.6-mile radius of some 30 attacks the teardrop rapist was accused of. In a recent interview, the teenager who was raped told investigators she stood by her identification, the Times reported, but prosecutors believe she honestly, but mistakenly identified Vargas. This problem is not uncommon, according to members of the Innocence Project. Bad eyewitness identifications are one of the leading causes of wrongful convictions, said project director and professor Justin Brooks. A judge reversed Vargas' conviction on Monday, and Vargas cried in the courtroom. "It's a relief because I believed that my father was innocent the day he told me he was innocent," his daughter Crystal Vargas said outside the courthouse. She said was she grateful for the California Innocence Project and its staff attorney Raquel Cohen, who worked on the case. Vargas was released to federal custody in connection with his immigration status. His green card was revoked when was under prosecution. The new allegations against the teardrop rapist come after Los Angeles police in January asked for the public's help in locating the person linked to 35 sexual assaults in a 16-year period. Although it has been almost 2 years since the last assault, the attacker is still out there, police said on a Facebook page created to help catch the assailant. "We have no fresh leads and are still looking for the community's help to identify the suspect." The teardrop rapist earned his name because of a teardrop tattoo witnesses said he had below one of his eyes. Police believe it may have been removed, and he may now have a scar where it once was. Number 9. On July 23, 2016, a fire chief wrongly accused of sex attack freed after 3 years in jail thanks to loyal wife's detective work. David and Lynn Bryant's living hell, as they call it, began 4 years ago with a note pushed through the letterbox of their home. Addressed to Mr. Bryant, the letter began, "Dave, it's Danny Day 35 years ago I used to collect the glasses in the Legion and I am the same one that you played darts with in the fire station, remember? At 6 o'clock tonight, I am going to the police station to report what went on and at 7 to the national papers. I think it is time you and me had a chat." The letter, obtained by the telegraph, concluded, "One way or another you will pay for what you done." His conviction was quashed last week by the Court of Appeal and he was freed from prison, but only after detective work led by his wife showed that his alleged victim was a fantasist. Speaking exclusively to the Telegraph, Mr. Bryant, now 66, and his wife Lynn, 53, have told of their determination to get the conviction overturned. "We made a conscious decision to stay strong," said Mrs. Bryant, recalling the day her husband was jailed in January 2014. "We were not going to let this man beat us. I continued to fight to get Dave cleared because it was so wrong. The support has been unwavering." Mrs. Bryant assembled a team of friends, lawyers, and private investigators, who did the job that detectives failed to do. They showed that Danny Day, who went to the police hours after delivering the letter in October 2012, was a serial liar who had sought medical help for his condition. Mr. Day, who waived his right to anonymity as the alleged victim of a sexual assault, accused Mr. Bryant, a decorated former fire chief and freeman of his hometown of Christchurch, in Dorset, of raping him at the local fire station some 35 years earlier when Mr. Day was about 14. "Danny Day is an evil man," said Mrs. Bryant, who was at school with him. "He was after the money. The Bryants are convinced Mr. Day made the false claims to extort money. Mr. Day, who is understood to have received about £50,000 as a victim of crime through the taxpayer-funded Criminal Injuries Compensation Scheme, after the trial began a £200,000 civil claim against the Bryants and Dorset County Council. Mr. Day, now aged 53 and living in Bromley, Kent, had been the bottle washer in the Royal British Legion bar in Christchurch where he had grown up in the 70s and where local firemen would regularly drink. Mr. Day would claim he had been raped over a pool table by Mr. Bryant and another fireman, Dennis Goodman, who is no longer alive, on an unspecified date between 1976 and 1978. Mr. Day had come forward in the wake of the uproar over Jimmy Savile, the BBC presenter and serial paedophile who escaped prosecution during his lifetime. "This could happen to any decent citizen," said Mr. Bryant. "That is the frightening thing about it. Somebody has made an absolutely ludicrous allegation and the police have run with it." Mr. Bryant was charged in 2013 with boogery, despite his accuser having no corroborating evidence for his claims. Police had failed to obtain medical records that showed Mr. Day had repeatedly sought treatment from his GP for being a chronic liar over a 10-year period between 2000 and 2010. Mrs. Bryant also discovered the police had been working off old plans for the fire station. These showed a different layout that did not tally with Mr. Day's testimony. The pool table, where Mr. Day claimed he was pinned down and raped, was not bought until 1992. But at a short trial just before Christmas 2013, Mr. Bryant was found guilty by a majority verdict and jailed. Mr. Day then began his civil action, claiming aggravated damages because he said his career as a champion boxer had been cut short by the trauma. He claimed he had been selected for the British boxing team at the Los Angeles Olympics in 1984 but had quit the team because of his fear that Mr. Bryant would recognize him on television. Mrs. Bryant's investigators discovered that Mr. Day's claims were lies, while lawyers demanded to see Mr. Day's medical records, showing a history of mental illness. A witness statement, corroborating Mr. Day's claims of a boxing career, had been written by Mr. Day and signed by a friend, who admitted the claims in it were false. The Bryants are calling for police to investigate Mr. Day and his friend for perverting the course of justice or for perjury. Mr. Bryant said, "Dorset police didn't do a proper job. Their mindset was, if a victim comes forward they are to be believed." Mrs. Bryant said, "Dorset police have never apologized. Now I wouldn't even expect it. A spokesman for Dorset Police said, Dorset Police takes allegations of this nature very seriously and conducted a very thorough and detailed investigation. The findings of the investigation were passed on to the Crown Prosecution Service, who chose to prosecute. We are yet to receive formal notification of the ruling from the Court of Appeal. When this is received, we will consider the findings in full. Number 8. Clarence Lee Brandley. As a janitor at a Texas high school in 1981, Brandley was accused and convicted of the rape and murder of a white student, 16-year-old Cheryl D. Ferguson, despite the lack of any physical evidence tying him to the crime. As evidence piled up to exonerate Brandley, and the role of racism in the investigation became clear, he was given a stay just 6 days before his scheduled execution. After a second trial, he was finally released in 1990. Number 7. On Tuesday morning, February 16, 2016, in Lakeport, California, a Lake County judge took swift action to set in motion the release of a man who has spent 18 years in state prison for a crime he did not commit. After meeting both in chambers and in open court with District Attorney Don Anderson and Attorney Angela Carter, who heads up the county's public defense contract, Judge Andrew Bloom signed a writ of habeas corpus to free Luther Ed Jones Jr. from state prison. Jones, 71, was sentenced to 27 years in prison after being convicted in 1998 of the sexual molestation of his ex-girlfriend's 10-year-old daughter. That young girl, now a 30-year-old woman, contacted the Lake County District Attorney's Office Victim Witness Division on February 9 to admit that her mother had told her to lie in retaliation for Jones winning custody of a 2-year-old daughter he and his ex-girlfriend had together. Anderson moved quickly to begin the process of seeking Jones' release in recent days, and partnered with Carter to bring the matter forward. He filed the writ of habeas corpus on Tuesday, and both he and Carter said later that they had expected the process to include the setting of a hearing within 15 days, Jones' transport to the county, and a local hearing before a release by the California Department of Corrections and Rehabilitation was finalized, which Carter estimated could have taken about a month and a half. However, after speaking with Anderson, Senior Deputy District Attorney Ed Borg, and Carter at length, going over the material, thoroughly questioning Anderson and asking him if he thought Jones was innocent, Bloom surprised them by granting the writ, saying he wanted Jones released immediately, according to Anderson. He didn't want the guy to spend another day in jail that he didn't have to, Anderson said. There had been some question about whether Bloom could hear the case, as he had worked in the district's attorney's office in the mid-1990s. However, Carter and Anderson said Bloom addressed that issue, explaining that he had left for a job in Micronesia by the time the case was filed. An elated Carter said Bloom's action took guts. He cut through bureaucratic tape in about an hour, she said. While innocent people do go to prison, Carter said the county's elected district attorney and elected judge acted in the fastest way possible to address the matter. It was handled exactly right. In her more than 20 years of practicing law in Lake County, Carter said, "I've never seen this happen before." Anderson, too, noted of the exoneration, "It is so rare, I've never seen one before," adding that his office isn't usually involved in working for prisoner release actions. Linda Starr, legal director of the Northern California Innocence Project at Santa Clara University School of Law, called Judge Bloom's actions really remarkable. She said it usually takes a much longer time frame for a writ of habeas corpus action, but it's often contested as well. Starr also lauded Anderson for doing the right thing by investigating the matter and moving quickly. "We all hope that that's the way it would work," Starr said. By Tuesday afternoon, the California Department of Corrections and Rehabilitation had received the writ approved by Bloom ordering Jones' release, according to spokesman Luis Patino. At that point, Anderson didn't believe Jones had been told of the developments. "They'll break the news to him," he said of prison officials. Here is the background of the case. As the matter has moved forward, it has revealed not just the injustice done to Jones, but the suffering of the young girl on whose testimony the case depended. Anderson's writ of habeas corpus filing seeking Jones' release explained that the falsified case against Jones, which began in 1996, had its roots in his turbulent and violent relationship with the mother of his then 2-year-old daughter. He had spent 6 months in jail for a domestic violence case against the woman, and after his release filed a paternity action to get custody of his young child, which was successful. On August 26, 1996, the court entered a judgment giving him the child, who he took custody of 2 days later with the assistance of the Clear Lake Police Department. On August 30, his ex-girlfriend's 10-year-old daughter reported to the principal at Lower Lake Elementary School that she had been the victim of sexual abuse. That set in motion a Clear Lake police investigation that led to a criminal filing against Jones on October 3, 1997, and his arrest 17 days later. He went to trial in February 1998, resulting in a hung jury, with jurors deadlocking 7-5 for conviction. At the end of March 1998, Jones' second trial, which lasted 4 days, began. The young girl who he was accused of victimizing testified, as did a medical expert regarding a physical exam the girl had undergone. Jones also testified, saying he was never home alone with the girl and that he believed she was being coached by her mother because of the case over his young daughter. A woman named Yolanda Davis also testified for the defense regarding a conversation she had with Jones' ex-girlfriend, who said she would never let him get custody of their daughter, and that she would put him in jail to keep him from getting custody. On April 8, 1998, the jury returned with guilty verdicts on counts of lewd and lascivious acts on a child under the age of 14, oral copulation with a minor child, harmful matter sent to seduce a minor child, forcible sexual penetration, dissuading a witness or victim, and assault and battery, according to Anderson's case history. Jones sought a new trial, but his motion was denied, and on June 12, 1998, he was sentenced to 27 years in prison. He subsequently appealed his conviction to the First District Court of Appeals, raising issues of inadmissible evidence, abuse of discretion, and insufficient evidence to sustain a conviction. The appellate court upheld the conviction. He sought the California Supreme Court's review of the case based on ineffective assistance of counsel, a request the court denied in June 1999. The truth revealed that earlier this year, the young woman who had been at the center of the case when she was a child contacted authorities and said that Jones did not in fact molest her, that she had been coached to accuse him by her mother, and that her mother's then-boyfriend had been the culprit for her sexual molestation, according to Anderson's report. On February 11, Bork and District Attorney Investigator Denise Hinchcliffe traveled out of county to talk to the young woman, who they found credible, Anderson said. She told them she was tired of having a heavy heart about Jones, who she recalled as being abusive to her mother. After she told the school principal about the alleged molestation, she remembered being picked up by Child Protective Services and, from that point forward, spending time in numerous foster homes both in and outside of Lake County. The young woman told District Attorney's office staff that her mother was heavily into drugs, had 6 children by 5 fathers, and moved constantly from house to house with her children in order to live with other drug users. On February 4, she said she told her grandmother about how she was having a hard time living with this lie, which she had told some other family members about but was afraid to bring up to her mother. Her grandmother told her she should come forward and tell the truth, which is why she ultimately contacted the victim witness office. The young woman said she contacted Jones' son, telling him she was afraid of his father. Jones' son supported her coming forward. Now clean, sober, and with a new baby of her own, the young woman told authorities that she felt she was ready to talk about the case. She said she has had no contact with Jones since the trial, and no one from her family or his had ever threatened her to come forward. She said it was just the right thing to do in her life right now, Hinchcliffe wrote in her interview report, adding that the young woman said she feels really bad about taking 20 years of Luther's life from him and his family, and she hopes he can get out and be able to spend time with his family. This woman is very brave for coming forward, said Starr. It's still a hard thing to come forward with that information. Good for her for doing that. Starr added, she will have a better life because of it. Still at issue is what legal action may be taken against the man who actually molested the woman when she was a child, as well as the mother who made her lie. Anderson said he hasn't yet looked at the question of prosecuting the alleged molester, but he cited potential concerns about the statute of limitations, the length of time since the crimes were committed and the fact that the woman has admitted to lying in court, which would make it difficult to convince a jury beyond a reasonable doubt that she wasn't lying again. He said there's no physical evidence to go on, but said his office will consider pursuing the matter. It would be difficult but possible, he said. As for the young woman's mother, who Anderson said no longer lives in Lake County, we know which city she's in but we haven't contacted her yet. He said his staff will try to interview her as well as recontact some of the case's other original witnesses to evaluate the potential for charging her. That also will be a difficult case due to the length of time that has passed. We've got a lot more work to do before we can make a decision, Anderson said. A state process is underway. While the California Department of Corrections and Rehabilitation had the signed writ of habeas corpus in hand within hours of Judge Bloom's decision, it was not clear when Jones would be released. We, by law, can have up to 5 days to process the release, said Patino. In that 5-day period the agency will go through records to make sure there are no other warrants or detainers, he said. With regard to Jones, although he did have a criminal history before his wrongful molestation conviction, warrants or detainers aren't likely to be an issue due to the length of time he's been in prison. We also make sure that if they have any medical conditions that they will have a continuum of care, said Patino. That is likely to be the most significant concern, as Jones has stated in court records that he has a variety of serious health conditions, among them diabetes, kidney problems, and hepatitis C. Anderson said that at a medical parole release hearing for Jones held in October, Jones was reported to be bedridden. Patino said Jones is currently being housed at the California Health Care Facility in Stockton. Noting that Jones' release due to exoneration is different than a regular parole, Patino said, everything will be done to help him reintegrate into society, with the hope that he can be placed with his family. The National Registry of Exonerations, a project of the University of Michigan Law School, tracks all known exonerations of convictions based on new evidence of innocence in the United States since 1989. According to the registry, since that time there have been 1,740 exonerations of convictions nationwide, and in California, exonerations as of Tuesday not counting Jones' case totaled 158. Of those California cases, the crime breakdown is as follows: murder/manslaughter, 70, sex crimes, 44, other, 24, robbery, 13, and drugs, 7. 61 of the defendants exonerated were Caucasian, 49 were black, 43 were Hispanic, and the ethnicity of the remaining 5 was classified as other. The average number of years lost for those convicted was 8.57, with a total of 1,354 years lost in serving prison sentences, the registry showed. While rare and remarkable, Jones' exoneration is not the only one to occur in Lake County since the National Registry of Exonerations began. In May 1997, University of California at Berkeley students Brendan Loftus and Arvind Balu, ages 23 and 21, respectively, at the time were charged with raping a 14-year-old girl at Canocti Harbor Resort and Spa. The case became known as the vampire rape case because the alleged victim said one of the men had cut her legs with a knife and licked the blood. According to the registry's details on the case, both men were convicted in October 1997, with Loftus sentenced to 5 years in prison and Balu found legally incompetent and put in a state mental facility. In July 1999, the California Court of Appeals set aside the convictions and ordered a hearing regarding evidence that had not been admitted, with a local judge upholding the convictions. The appellate court vacated Loftus' convictions and Balu's rapid conviction in July 2000. 3 months later, the Lake County District Attorney's Office dropped the charges against Loftus, and in 2006 Balu's convictions were set aside and, ultimately, the charges were dismissed. Number 6. James Bain. James Bain spent more time in prison for a crime he did not commit than any other American exonerated through DNA evidence. In 1974, At the age of 19, Bain was convicted of rape and kidnapping. He was released in 2009 at the age of 54. On the evening of March 4, 1974, a 9-year-old boy sleeping at his home in Lake Wales, Florida, was dragged to a baseball field and raped. Investigation and trial. The victim told police that his assailant appeared to have been 17 or 18 years old and had a mustache and bushy sideburns. According to the victim, the man had said his name was Jim or Jimmy. The victim's uncle thought this description sounded a lot like Jimmy Bain. Police showed the victim 5 or 6 photographs of potential suspects and he chose the one of Bain. However, of the photographs in the lineup, only Bain and one other man had sideburns. The police questioned Bain at his home at around midnight on March 5, 1974. Bain claimed that he had been at home watching television at the time of the attack, an alibi that was supported by Bain's sister. Nevertheless, the police arrested him. According to FBI analysis presented at the trial, the rapist did leave semen on the victim's underwear. The trial occurred, however, before DNA testing was available, so Bain could not be definitively tied to the semen. He could, however, match its blood group. A FBI analyst testified that the semen on the underwear was of blood group B. Bain's blood group was AB, but according to the analyst, Bain's group had a weak A and thus he could not be excluded from having deposited the semen. An expert for the defense testified that Bain's group actually had a strong A, and therefore he could be definitively excluded. In spite of this conflicting serological evidence and Bain's alibi, Bain was convicted of rape, kidnapping, and burglary and sentenced to life in prison. The prosecution's case rested largely on the victim's identification of Bain in the photo lineup. Post-conviction investigation. A 2001 Florida statute made it possible for certain cases to be reopened for DNA testing. Upon hearing this, Bain presented 4 handwritten motions for the DNA evidence in his case to be tested. In all, the case came before the court 5 times and was denied all 5 times. With the aid of the Innocence Project of Florida and 10th Judicial Circuit Public Defender Bob Young, Bain was finally granted access to post-conviction DNA testing. The state sent the DNA found on the victim's underwear to the DNA Diagnostics Center. This testing excluded Bain as the source of the DNA. The Polk County State Attorney, Jerry Hill, then joined the defense in a motion to declare Bain innocent. On December 17, 2009, a judge signed the order releasing Bain from prison after 35 years. As soon as Bain was released, he used a cell phone for the first time to call his mother. His life after exoneration. Bain received $1.7 million from the state of Florida for his wrongful conviction, $50,000 for every year he spent in prison. His mother also put her house and her car in her son's name, stating, "I want him to have something by himself. He's suffered enough." Bain is a leading advocate for the innocence movement, sharing his wrongful conviction experience from middle schools to colleges across the country. During an event at Florida Southern College, a student asked him what he thought about all the technology he's seen since his release. Bain said that cars and telephones were the most surprising to him. Even though there had been cars before he was incarcerated, he explained that there were none that talked back to me. He is married, has a young son, and is now in the process of writing a book. Number 5. A Virginia man was released from prison in November 2012 after spending 4 years behind bars for a crime he didn't commit. When a 17-year-old girl falsely accused him of molesting her, the innocent man was locked up, losing years of his life. "The truth sets you free," 26-year-old Jonathan Montgomery told reporters on the night of his release from the Greensville Correctional Center. Montgomery was falsely convicted of molesting Elizabeth Page Coast 4 years ago. At the age of 17, Coast was caught watching pornography by her parents. In an attempt to explain her behavior, the teenage girl told her distraught parents that she had been sexually abused while she was 10 years old. Pressured to reveal details, Coast told her parents that she was molested by Montgomery, who previously lived across the street from her grandmother in Hampton, VA. The two kids used to play together when Montgomery was 14. The teenager did not believe anyone would come after Montgomery, especially since his family had just moved to Florida. But Virginia prosecutors convicted him of aggravated sexual battery and sentenced him to 7.5 years imprisonment. Since she was a victim in the case, every time we did something in the courts she received a notification. Every time we did something in the courts it reminded her of this lie, and maybe it finally got to her, Montgomery's father, Dave Montgomery, told the Associated Press. Coast recanted her story shortly before Thanksgiving, prompting Virginia Governor Bob McDonnell to issue a conditional pardon to Montgomery and freeing him Tuesday. Coast was arrested and charged with perjury for fabricating the assault story. She is currently out of jail on bond with a court-appointed attorney. Montgomery left the prison with few items and headed to Walmart to buy new clothes. With nothing but a photo album, shower shoes, and some books, the young man must now build a life that the prison deprived him from. The conditional pardon he was granted requires him to remain in the state of Virginia while he is on probation. He must also file a writ of actual innocence within 30 days of his release. The man was, however, given a pass to leave the state to visit his family in Florida for Thanksgiving. I can say that the good comes out of the bad and you got to keep fighting, you got to keep telling everybody you know what's right and you know what's wrong, Montgomery said during a news conference after his release. As long as someone is there listening to you, you just got to keep going. Montgomery told reporters that he will never be able to forgive Coast for what she did to him. His bitterness did subside after she recanted. I won't forget, he said. I can't forgive her, but I'm thankful she came forward with the truth. It was probably harder for her than it was for me. The young man said he plans to write a book about his ordeal. Number 4. North Carolina man freed after being falsely accused of molesting daughter. A Lenoir County man in Kinston, North Carolina was granted his freedom on March 2, 2016 after serving over 2 decades in prison for a crime he says he did not commit. A Lenoir County judge decided to free Howard Dudley on Wednesday after rehearing his case. The judge overturned Dudley's 1992 conviction citing a miscarriage of justice. In 1991, his daughter claimed he molested her. He denied it. He maintained his innocence once again, refusing to take a plea in 1992. That's when he was sentenced to life in prison. His daughter then recanted her story, even testifying in court years later that she lied at trial. And Tuesday, Amy Dudley faced her father in court once again saying she lied. On Wednesday, Dudley took the stand telling the court he wants to clear his name. He said he does not want to be associated with the horrible crime. He said he is up for parole April 22, but that he would not consider that a chance for freedom because it would be parole for a crime he did not commit. Tuesday's hearing was the start of a kind of mini-trial for Dudley. His family said they hope it's also the start of a new beginning for their loved one. Dozens of people filled the Lenoir County Courthouse room to hear the proceedings. A number of people from Dudley's family were also present. Attorneys spent hours presenting evidence and questioning witnesses. Dudley's attorneys argued his innocence, saying the main witness, his daughter, recanted her testimony and lied about being molested by her father. The other side said Dudley's original trial was fair. Dudley had a chance to take a plea deal, but he refused to admit to something he said he didn't do. And his family not only believes him, they look up to him. To spend that much time, in a jail situation, where he could have gotten out just by admitting he did it, saying he did something that he didn't do, I admire him for what he's done, said Ella King, Dudley's sister. Dudley's family is confident the process will end in him being a free man. They just hope everything is over sooner rather than later. Number 3. Utah man vindicated after serving 15 years for child sexual abuse. Kevin Peterson's case is full of contradictions. He did it. He didn't do it. Then he did. But just days before his 55th birthday in late December, Peterson, who finished serving a 15-year sentence for the alleged crime in 2007, was cleared unequivocally of all wrongdoing after his kids recanted their allegations that he sexually abused them. While 4 people have been declared factually innocent since Utah's law went into effect in May 2008, Peterson's finding is only the second case uncontested by the state. A factual innocence ruling by the court declares a convicted person did not engage in the conduct for which they were found guilty due to new or changing evidence. DNA evidence can be used, but is not required, to prove factual innocence. But by the time he was cleared, the Weber County resident had already served 15 years in prison, the entirety of his sentence, and was required to register as a sex offender. Peterson, who now works as a truck driver, declined to comment through one of his attorneys, Jason Richards, who represented him on the innocence case. "It's just a tragic case, Richards. It just took forever for him to be vindicated. He's an upright, good person," Richards said. "He just got an extremely bad break. Everything just lined up against him." Peterson was falsely accused. In 1990, the then 32-year-old Peterson was involved in a contentious custody battle over his 5-year-old daughter and 8-year-old son. The courts had granted him preliminary custody until allegations surfaced that he had sexually abused both children and his then stepdaughter, Richards said. "Then the police showed up and took his kids away and arrested him," Richards said. The courts stripped him of custody, which Richards said was the intent of the children's mother. He was forced to sit in court and listen as his young son testified against him during a preliminary hearing. State records indicate his daughter was so hysterical she couldn't take the stand. After listening to his child, Peterson thought, "I don't got a chance in hell." So that's why he pleaded, Richards said, noting his client was facing a prison sentence of 5 years to life if convicted of a first-degree felony. Peterson pleaded guilty to a lesser second-degree felony count of sexual abuse of a child and was sentenced to 36 months probation. As part of that plea, he was required to complete sex offender treatment. But buried deep in the plea agreement papers at the time was a unique caveat: "I did not sexually abuse my son. However, after being fully advised as to the consequences of my decision by my attorney, I want to plead guilty to the second-degree felony." Punishment is tempered with mercy in treatment programs, but only if the person accepts personal responsibility for their actions, said Scott Reed, Division Chief of the Criminal Justice Division of the Utah Attorney General's Office, who represented the state in legal proceedings. "It's tragic in that respect," Reed said. "Tragic because that was the point when the problems arose," Richards said. "Once he had pleaded guilty without admitting guilt, he was kind of stuck," Richards said. "He couldn't very well go back and change his mind after the appeal time had run." Richards said Peterson was required to admit to the sexual abuse and write in detail what he had done to the children. "He wasn't going to stay out of prison unless he admitted and wrote down stuff," Richards said. "He had no idea what to do or what to say." Richards said Peterson had people in his therapy group who had committed the sex offenses help him write up a plausible description. But treatment counselors were unhappy with Peterson's failure to admit to the sexual abuse, so they sought to revoke his probation. He was sent to prison for 15 years, serving every single day of that sentence. He was released November 8, 2007. "He wasn't willing to admit wrongdoing because he didn't do anything," Richards said. "So, yeah, he served every day of those 15 years. No parole." Peterson likely didn't help his case, though, at his first parole hearing in November 1993. When confronted by parole hearing officer Curtis Garner, Peterson acknowledged that he had molested his children for 18 months to 2 years by touching and rubbing the vaginal area of his daughter and by having his son rub his genital area, according to tapes of the hearing obtained by the Salt Lake Tribune through an open records request. Richards said he didn't know for sure why Peterson admitted to the offense, but said it was likely because his client was desperate to get out and believed simply admitting guilt would sway the parole board. "Prison is a hellish place to be," Richards said. "I bet if you talk to a lot of people there, they'd pretty much say anything to get out of there." He'd go back and forth because he was scared. Law enforcement also reported to the parole board that Peterson was in total denial and laying guilt trips on the children for making accusations against him. Then there were conflicting reports from two psychologists who disagreed about the likelihood of Peterson reoffending upon release, coupled with his apparent refusal to participate in prison treatment. The board has a pretty hard position on people who refuse to become involved in sex therapy that's available here, Garner told Peterson. I mean, you basically have to satisfy us that you're no longer a risk to reoffend before we're willing to vote to get you out. And when you fail the program that's provided you as a condition of probation, that doesn't speak very well of your likelihood of success. Garner warned Peterson to take a good look at his 2007 sentence expiration date because that's the date you're facing if you don't do some good programming. I'm not encouraged by what I'm hearing here today, Garner added. Parts of the 1993 hearing tapes are inaudible and all of the 1995 rehearing was inaudible, although paperwork pertaining to the 1995 hearing indicated that the parole board found that Peterson had no remorse or apparent motivation to rehabilitate by his refusal to participate in available sex offender treatment, which he needs, and his refusal to submit to another psychological evaluation. It's a compelling thing to be willing to stay in prison when you could just get out and say you did it, Richards said. It was only after Peterson was released that his son and daughter came forward and recanted. His now adult son wept as he explained to officials that he had lied. Despite being framed, Peterson holds no ill will toward his children. Peterson honestly doesn't blame them at all because they were so little, Richards said. Wrongful conviction. Reed said many factual innocence cases involving DNA evidence are pretty straightforward. But then there are cases like Peterson's, in which a victim comes forward years later and recants, which raises the question of whether to believe the victim now or then. I think it takes a certain amount of courage even as an adult to come forward, Reed said. But Reed said the state did everything it could to ensure Peterson got a fair shake from the start and there was no misconduct or coercion on its part. They had the evidence, including the compelling testimony of Peterson's own son. They didn't do anything wrong, Reed said. It's just a sad situation. He also noted there were some weird aspects to the case, including the fact that Peterson pleaded guilty. You can't waver from it. You can't compromise, he said of a defendant's insistence on being innocent. The guy pleaded guilty. Got probation. He had the keys to the jailhouse in his hands. Then he got obstinate and refused to cooperate with sex offender treatment. But Reed said he personally is more convinced of innocence in this case than in some of the 14 other factual innocence petitions that have been filed in Utah since 2008. He just wanted to clear his name, Reed said, noting the state could help accomplish his objective and do it in such a way that it didn't incur excessive financial liability to taxpayers. Peterson's wrongful conviction cost Utah taxpayers $70,000 as part of a settlement that was sealed until the Tribune filed a motion seeking to make the agreement public. Earlier this month, the document was unsealed. As part of the settlement, Peterson's record was expunged and he is no longer required to register as a sex offender. Now that he's been cleared, Richards said his client is focused on moving forward with his life. Kevin is really resilient, Richards said. Deborah Brown served 17 years in prison for a 1993 shooting death of Lael Brown in Logan. Awarded more than $500,000. Jed Gressman served 3 years in prison for an aggravated sexual assault before being cleared by DNA evidence of the crime. Awarded $220,000. Harry Miller served 4.5 years in prison for a robbery he didn't commit. Awarded an estimated $120,000. Kevin Peterson served 15 years in prison for a sex abuse of a child. Awarded $70,000. State is appealing factual innocence finding. Number 2. Wrongly convicted, Roger Olson gets $475,000 for 2 years in Minnesota prison. After wrongfully being convicted of criminal sexual conduct involving a minor and spending 2 years in a Stillwater prison, Roger Olson, 50, will be compensated $475,000 by the state, his attorney said Tuesday. While in prison, Olson was subjected to assaults and abuse by inmates who targeted him not only because of his quiet and peaceful demeanor, but because he had been falsely labeled as a child rapist, his attorney Steve Meshbisher said. Olsen said getting compensated for being locked up from 2006 to 2008 does not right a wrong, or change the damage that's been done. He said in the years since he got out, people still treat him differently, and he's had a hard time moving past what happened in prison. I didn't expect to live in there. Everybody gets beat, raped, all kinds of stuff in there, Olsen said. Olsen, of Law Crescent, was released from prison in 2008 when investigators found evidence that the accuser fabricated the story. In 2007, the alleged victim, his former stepdaughter, accused her mother's new boyfriend of identical sexual abuse, and it raised red flags. As the county attorney's office that originally prosecuted Mr. Olsen has acknowledged, evidence came to light after Mr. Olsen's conviction that affirmatively proves he is an innocent man, Meshbisher said. Olsen said the 2 years he spent locked up in Stillwater changed him permanently as he desperately tried to keep convincing people he was innocent. I tried to fight my way out of it by writing all kinds of letters, got all kinds of denials. At one point, I tried to take my life in there, he said. In the years since, Olsen said he's still depressed and still struggles to find work. I went to 5 different states with the papers and all my expunge papers. I just can't get certain people to believe it. And finally, number 1. Melbourne teacher wrongly imprisoned for child abuse demands investigation. Melbourne teacher Annette Toohey says Victoria Police must launch an immediate investigation into the circumstances that led to her sister Josephine Greensill being wrongly jailed for nearly 2.5 years. It's outrageous that my sister was jailed, Ms. Toohey told the ABC's Australian Story. And it's outrageous that since her acquittal there has been no apology for what has happened to her, no one has been held to account. We want a full investigation into this and we won't stop until we get that. Ms. Greensill, a retired teacher, was 59 years old when she went to prison after 2 men accused her of child sexual abuse, including full intercourse when they were 8 years old and she was their Year 3 teacher. From the outset, Ms. Greensill protested her innocence. But in June 2010 a jury found her guilty of 9 of 20 charges, all relating to an alleged incident in a tent in her backyard. Top criminal lawyer investigates criminal lawyer Robert Sterry, who took on the case a year after Ms. Greensill's conviction, said in 30 years of practice it was very rare for him to be so strident about a person's innocence. Right from the very outset, we thought that there was something untoward about that conviction, he said. For Mr. Sterry, much of the evidence in the case didn't stack up. The thing that struck me most is the complete implausibility of the allegations, he said. The fact that they as prepubescent children claim to have had firstly penile sexual intercourse with Josephine and then in their account describing how they've ejaculated. Their description of the events really beggars belief. Ms. Greensill said she would have languished in prison for much longer had it not been for the dedication and persistence of Mr. Sterry and her family. All convictions quashed. In a unanimous appeal decision in November 2012, 3 Supreme Court judges acquitted Ms. Greensill and quashed all convictions. Photo: Annette Toohey, left, Josephine Greensill and Mary Toohey, right, offered Josephine valuable support, Stavros Sakalaris. They were incredulous as to the nature of the evidence and the conviction, Mr. Sterry said of the judge's decision. The judges gave 9 reasons for their decision, including a real likelihood the 2 complainants had collaborated and a real possibility of concoction. They also cited considerable inconsistency in the evidence of the men, a lack of medical and forensic evidence, and a possible financial motive relating to the prospect of compensation. When I left jail, I was 61 and I'd served 2 years, 5 months, and 13 days, Ms. Greensill said. The toll on her health has been substantial, both physically and mentally, and she has been diagnosed with post-traumatic stress disorder. One of the most distressing things about the time in jail was that I missed important family events, like my auntie's 90th, a few 60ths that I missed, including my own 60th birthday, she said. I had 3 grandchildren born. And one of my sisters got breast cancer and I wasn't there to support her. And sadly my son-in-law passed away and I wasn't allowed to go to the funeral. No reason given, just no, you can't go. It was really tough knowing that all these things were happening, really important things in my life, as I love my family, and that I couldn't participate in them. Mr. Sterry said it was unacceptable there were no consequences for those responsible for what happened to Ms. Greensill. Police consider further investigation. In 2015, Victoria Police said a special crime investigation unit was considering whether to investigate the men who made the allegations in relation to possible perjury, perverting the course of justice and conspiracy. Photo: Josephine Greensill has been diagnosed with post-traumatic stress disorder, Stavros Sakalaris. But Ms. Toohey is angry. She and her sister have heard nothing from the police since January. "We want something to happen," Ms. Toohey said. "This has been a dreadful miscarriage of justice and she deserves to have justice." Victoria Police told the ABC the special investigators' review is ongoing. Australian Story spoke with the first complainant, who declined an on-camera interview, and the second complainant did not respond to the program's inquiries. Government rejects compensation claim. In the 7 years since the allegations emerged, Ms. Greensill has not been arrested or charged with any other offences. In light of what the Court of Appeal has said, this case should never have gone before a jury. Lawyer Robert Sterry. Ms. Greensill said she has spent well in excess of $200,000 to defend herself since the case began. Victorian Attorney General Martin Pakula rejected an application for an ex gratia payment to compensate her for what happened, saying her case did not fit the criteria of suffering a financial loss or other detriment directly as a result of the workings of government. No other form of government compensation is open to Ms. Greensill. A leading Melbourne QC is understood to be currently assessing this decision. Mr. Sterry believes the Victorian government should be accepting responsibility. In light of what the Court of Appeal has said, this case should never have gone before a jury, he said. Ms. Greensill's family said their experience of the judicial system was a warning to others. She was innocent, Ms. Toohey said. If it could happen to her, it could happen to anybody. That is your top 10 list of times when child sex abuse reports should have never been accepted because those 10 people became victims of false child sex predators. There are a lot more victims out there of false child sex abusers that were not mentioned in this video, and there are still people today who are suffering for no reason that we currently do not know about. So know your boundaries when protecting children, and I hope this video encourages other children, parents, and police officers to not be too serious about child molestation and the sex offender registry. Take care, and I hope this helps.